Sorry, are you going to start?
You are live and ready to go.
Okay, that sounds good. Good morning, everyone. My name is Andrew Moore. I'm an attorney here in San Diego. I wanted to first start out by saying this webinar is brought to you by the North San Diego County Realtors. And I'm here this morning to just go over the foreclosure and short sale process generally in California from a legal perspective, and hopefully to answer some of your questions and just again kind of go through the process so that some of the things that may be confusing about the legal end of it and about client expectations and so forth can be answered and cleared up, which will hopefully help with the sale process, you know, from the realtor side of things. I have the chat open here, so I'm happy to answer any questions. If you guys want to send any questions during the seminar as I'm talking, I'll try my hardest to get through to everything. If I don't answer anything during this live seminar, feel free to contact me. My contact information will be available at the end of the seminar as well. I'm happy to talk to you guys about anything that might come up, either in actual cases or just kind of generally speaking as you go through your practice. I'm going to start here just kind of from the basics. Hold on. There we go. From the basics of the foreclosure process and go into what happens when I, as an attorney, deal with a client who's in foreclosure and what realtors also can do, especially because clients, as I'm sure you guys know, tend to think they know everything about everything and they know a lot about the law, and they'll start parroting advice that they got from attorneys or they read on the internet, and that can really derail a process where you're trying to sell a home or short sell a home for them. And so this advice hopefully will be helpful with some of that. So just to start, the first steps here are the types of foreclosures in California. There's two types of foreclosures in California. There's a judicial foreclosure and a non-judicial foreclosure. And the vast majority of all foreclosures here in California are going to be non-judicial foreclosures, and they're also called trustee sales. So that's the primary thing we're going to be dealing with. But I do want to go through a judicial foreclosure because it does happen once in a while, and it's good to know about. And a lot of people are not aware that this is even, you know, kind of a thing here in California because it's so rare. But this tends to occur on very high-end properties because, as I'll explain later in this seminar, when you have a non-judicial foreclosure or a trustee sale, the lenders cannot normally get deficiency judgments. So let's say you have a property whose value is $1 million, but there's $2.5 million owed to the lender. It could be worth it for them to go through a judicial foreclosure because if they sue, go through the judicial process, they can get a deficiency judgment, and then they can get, you know, the $1.5 million difference or whatever it may be in a judgment against the homeowner. And again, that's kind of a case-by-case basis where you're looking at a situation as a bank or as a private lender where you're saying, does the homeowner have other assets? Is it worth it if I get a $1.5 million judgment against them? Or if they're insolvent and don't have anything, you know, maybe it's just better to go through the trustee sale process because the process for judicial foreclosure is expensive, very time consuming for the lien holder. And so they've just got to make sure that it's worth it. Less than 5% of foreclosures in California typically are judicial foreclosures. And there's some other caveats that go along with this process. For example, the borrower, after the foreclosure is done with a judicial foreclosure, they have a right of redemption. So they either have 3 months or 12 months, depending on if there's deficiency judgment, to basically pay back the amount that's owed. And so that, again, complicates the situation for the lender because they don't have finality on the process. It's hard to resell it and so forth. And so for those reasons, again, this is usually not used by most lenders. There were suspensions during COVID for some of these judicial foreclosures. Those have all expired. A lot of the, and I'll talk about this later in more detail, but a lot of the changes for COVID, the relief that was sent by the state, by the federal government, has expired. There's really only one program left in California that can help with the foreclosure process that was specifically done for the pandemic. We'll go through that in detail. But a lot of these notes about the relief that was around 2020 and to some extent in 2021 in the last couple of years. It may change again. I mean, it's a moving process here, and so laws are constantly changing, and it's important to stay on top of that and on top of the different relief that may be offered by the state, the federal government, the county, and so forth. Now we go to the non-judicial foreclosures, which is most of what we all see. That's the vast majority of foreclosures in California are non-judicial. The basis for the non-judicial foreclosure is contained in the power of sale clause in the deed of trust. And in certain other states, many other states have just judicial foreclosure. So a lot of the states on the East Coast, for example, if you're going to do a foreclosure, the bank has to go into court, file a complaint. The homeowner can answer it. They can say, well, this is not valid for X, Y, and Z, or I'm actually not behind on my payments. I'm in compliance with the contract. Things like that. You have much more of a standardized process with a lot more due process rights, I think, for the homeowner. In California, because of the way the California laws are set up, when you sign the deed of trust, when you sign the note, you're basically giving the bank power to go through this trustee sale process if you default. And again, non-judicial foreclosure and trustee sale are the same thing. They're two words for the same thing. And when you have a trustee sale, what happens is a bank, let's say Chase or Wells Fargo or any bank or the servicer, it's like portfolio servicing, SLS, whatever it may be, they farm out the actual foreclosure process typically to a third-party trustee. And that third-party trustee, and some of the more famous ones are like Cal Western Reconveyance, I think. There's a bunch of different ones that basically all they do is they're mills. They're technically law firms, but they don't really do any legal part of it. They're not going to answer legal advice. All they're doing is getting their direction from the lender or the servicer, and then they're conducting the foreclosure sale. So they're sending out a notice of default. They're sending out a notice of sale. We'll talk about those in more detail in a minute. But they're the ones conducting it. They're the ones who have a trustee sale number. They're the ones who contact to stop the foreclosure sale if there's been a bankruptcy filed or some other reason that the sale has to be stopped. And they're kind of the middleman. And again, I'll talk about this a little bit more later, but what happens is they kind of create a smokescreen, if you will. That's, I guess, from my perspective, but they create a middleman situation where it's very hard to get through to the lender itself. And they're the ones conducting the actual foreclosure. They're the ones doing the auction and so forth. Something really, really, really important here is that the trustee sales are subject to what's called the one form of action rule, which is contained in California Civil Code Section 580. And the one form of action rule is extremely important, meaning that the foreclosing lender, let's say the first mortgage in this previous scenario, they are $2.5 million. The house is worth $1 million. When they foreclose, they can't choose to try to collect the $2.5 million and let the borrower keep the house. They have to go after the house. That's actually a different part of the one form of action rule called security first, but it's all contained in the same thing. And so if they go after the house and they foreclose, they can't then come back and say, well, you also owe me the difference. That would be a second form of action. So they have to go after the one form of action, which is the foreclosure. And what that does in practicality is that prevents a bunch of judgments and a bunch of collections against homeowners who get foreclosed on underwater properties. As you guys I'm sure know, the real estate market in California has gone up dramatically over the last few years. This used to be much more of an issue where there used to be a lot more houses that were dramatically underwater. There still are some houses, I think, that are underwater, but the landscape's changing a lot. Of course, the last couple of months, the market is beginning to kind of go down again in California, and so it's always a moving target. But there are always going to be properties that are underwater because people have borrowed or because of the timing of the borrowing and so forth. So it's important to know that if you get foreclosed on, the bank cannot come after you. The foreclosing bank cannot come after you for that deficiency. And then again, one of the reasons I'm going through this whole process with you guys right now is because it's important when you're doing a sale, a short sale, when you're helping a client trying to figure out what their process is going to be for selling the house, to understand what's going on with the foreclosure process so that they don't get foreclosed on while you're selling the house, and also just to discuss with the clients, because a lot of people misunderstand this process, and they will be selling a house, for example, and they'll get a notice of default, which I'm about to talk about, and they'll say, well, I can't sell the house anymore, so I'm going to go a different direction, and I'm going to sue the bank, or I'm just going to give up, or whatever it may be. So to know this process, I think it really helps for the realtor perspective to maximize your income, maximize the success of the sales, and so forth. The official foreclosure process in California starts with the filing of a notice of default. And the notice of default is actually, the full name is the notice of default and election to sell under deed of trust. This is typically mailed by certified mail, and it's recorded with the county. And so the client will get this notice of default. There's a lot of confusion among just the general population when they receive a letter from the bank, and the bank might say you are 2 months behind, you are in default on the loan. And we'll say, well, I received a notice of default, and they'll start thinking that that's the same thing. Again, this is an official notice, and I'm sure a lot of you know a lot of this already. Just kind of going through this piecemeal so that there's no gaps. But a lot of people that I've seen will say, well, yeah, I got a notice of default 12 months ago, and I got another notice of default 2 months ago, and they won't know which one is which or what matters. The notice of default and election to sell under deed of trust is a really, really important document because it starts the official foreclosure process. And anytime after the default on the note, so anytime after they fall behind on payments, at least 120 days, the bank is legally allowed to file that notice of default and election to sell. And once that, and the notice of default, once it's filed, it must contain certain information. And it's got to identify the property, it's got to identify the type of breach that has occurred, for example, the default on the contractual payments or the failure to maintain insurance. Another one I've been seeing a lot of is a notice of default because the loan has come due. So a lot of people will have taken out a loan that is a 10-year note, 15-year note, have just completely forgotten about the end of it because they have a balloon payment due at the end. And they'll say, well, I thought this payment, I didn't realize that this had come due, and I just thought I was behind 2 months, and so I thought I could catch up. But actually, the notice of default will say you owe the entire note, and because this has come due and you haven't paid the balloon payment, we're going to go forward with foreclosure. So again, really important for people to understand, why they're in default, and that's important for the bank to tell them exactly why they're in default. If they don't do any of this in this paragraph, in the second paragraph, then there is usually grounds for a lawsuit to stop the foreclosure and make them restart the process, which oftentimes, again, if someone's trying to sell and their sale date's in 5 days, and then this was the notice of default didn't explain why there was a default, this can be a really good mechanism for buying them more time to allow them to sell and to get that done. The notice of default has to include the third-party trustee's contact information. So like CalBuster Reconveyance, let's say they're the trustee selling the house, it has to have that information on there. If it doesn't, again, there's probably ways to stop that sale if you have enough time. And it's important because you need someone to be able to communicate with in case you need to stop the sale, in case you need to ask questions, in case you need to just communicate. I've rarely seen it where they don't include that information, but that's a good place to start. Look on the notice of default to look for that trustee. And if there is a default, if that's the reason for the notice of default, there's a default on payments, it's got to include the amount necessary to cure the default at that time. Remember always that if a notice of default says, for example, the default on payments is $27,300, that if someone, cures it 2 or 3 months later and says, well, I'm out of foreclosure now, they need to pay the $27,300 plus whatever has come due since that notice of default was filed. Again, a major thing I see with clients who come in and they say, well, I cured the default and they're still trying to foreclose. That can't be legal. And you got to look at that and say, well, when was the default notice filed? How much was owed at that time? And how much has come due since then? And of course, you also are looking at a situation where the bank and their attorneys are probably going to charge attorney's fees, possibly, other penalties, possibly escrow has come due if they're paying, if it's impounded and they're paying taxes and insurance. There may be other fees and amounts due. So you've always got to call that third-party trustee, the person, the company in that above paragraph and just listed on the notice of default, and say, what is the current reinstatement amount? Get the reinstatement amount as of a certain day. Sometimes they'll say the reinstatement amount is X, plus you have a per diem amount you also have to catch up on. And so you need to get that exact amount if they're going to cure the default. Again, I understand that it's not necessarily what you're trying to do to have them cure the default, but it is valuable information to know exactly what they're doing and to be able to speak the language, because you got a lot of attorneys out there and a lot of companies that are kind of faking the attorneys, if you will, that are advising people, oh, this is what you do, this is what you do, this is what you do. And the more information you have, the more power you have to really advise, clients, not legally, obviously, but to be able to understand and advise them on the sale part of it, and to know the language they're speaking and the common errors they're making to make sure to be able to complete as many sales as possible successfully. After the notice of default is filed, after the notice of default is filed, the bank has to wait at least 90 days, give you 90 days to cure the default. If the borrower does not cure the default within 90 days, the bank can then set a notice of sale. The notice of sale has to give another 20 days. So in essence, from that notice of default and election to sell under deed of trust, the borrower has 110 days to cure. If the borrower is in the process of a sale, all that does is it gives you a timeline and says you got to close within 110 days to be completely safe. All the rest of this will just go along and will process, but if you sell it, they can't stop you from selling it. They have 110 days at least to sell the property. Keep in mind that once that notice of default is filed, the borrower is going to start getting flooded with probably 20, 30 flyers a day from all sorts of companies, all sorts of attorneys, probably all sorts of realtors. And they're going to be making promises and saying things that are sometimes true and sometimes not at all true, about how, for example, some attorneys will send flyers and they'll say, the bank has no right to foreclose on you. There's been an error in your loan documents. All you need to do is pay us a bunch of money, and then they won't be able to foreclose. So contact us today. It's important to maybe have a communication with your client and have them be ready if they're going to get a notice of default, or if they did, to know that there's a lot of that information out there, and to just be careful, because there are a lot of scams. There are a lot of ruthless attorneys, and there's a lot of people who are just trying to take away your sale by giving false options. And sometimes the options are not false. I mean, there are legitimate options for saving a house, and I'll talk about those a little bit later. But a lot of the times they're just people that are saying whatever they need to say to get paid. And oftentimes that's an actual violation of the law, the way they're getting paid. And it's important to know that, as soon as that notice of default is filed with the county, it hits a lot of lists, and it hits a lot of marketing lists. You guys may know that from your side as well. So just be aware that clients will come back and they'll start to be confused right after that happens. They'll probably start asking a lot of questions. They may start talking to other people. They may try to back out of the sale. It's important to know your rights at that point. After the 90 days from the notice of default, the notice of sale is filed. And the notice of sale is typically posted on the door of the home. And the notice of sale will say how much the total amount is for the loan. So this is not saying, like the notice of default, how much the default amount is to catch up. This is saying how much the entire loan balance is at that point. It can be confusing for clients and for other people involved because they're two different numbers. But again, you can always get the reinstatement amount from the third-party trustee, and that's what you want to do if they're trying to catch up. So if someone says, well, I can catch up, I can pay back the amount, so I don't need to sell, and you'll say, well, how much did it say on the notice of default? And they'll say, well, $32,000, but I'm just going to pay part of it now, and I'll pay part of it later, something like that. It's good to know from every side that that's not going to work. You can pay, if you owe $32,000 and then you got another $8,000 that's come due, you can't just pay part of it and it'll stop the foreclosure. You need to pay the entire amount out of the penny, or else they're still going to foreclose. And now that you've got so many properties with equity, it's really important to know that, so that people don't mistakenly miss out on their equity and not sell the house when they have an opportunity to do so. The borrower technically has the right to reinstate the loan even after that notice of sale is filed. They can do it by curing the entire default, including the fees and costs, and technically they have to do it at least 5 days before the foreclosure sale. There's something called the tender rule, which is very rarely enforced, but it's something to know about because it happens a lot when there's mistakes made at the end, when there's miscommunications, where someone can cure, they'll say, well, you owe $65,000, and they'll wait until the day before the sale or the morning of the sale, and they'll wire the money. And if there's a mistake, if the bank still forecloses, they can technically go into court and say, well, the tender rule says they have to give us at least 5 days prior to the foreclosure sale to cure it. So you have situations where people do cure, but the bank still forecloses. It's extremely rare. It's just something to know about. But again, it's just something to know in this process. So I set out this chart here. for just kind of general timelines for these processes. I'm not going to go through them again right now, but if you want to go through the PDF here, or the PowerPoint, you can definitely look at that. If you want to contact me about any of these questions, I'm happy to talk about these and give any further guidance. And again, this is just kind of the process for the foreclosure, for the trustee sales. You get the default letter, you get the notice of default, and then you get the notice of sale. When a client comes to me as a lawyer in California and they're facing foreclosure, there's a number of options that I typically go through with them, depending on the situations. Obviously, sometimes people, one or multiple of these don't apply, but a lot of people have a lot of questions about all of them, and sometimes people will go to different attorneys or different resources for the different options. As a lawyer, I think it's important that you're able to advise on all these different options and able to give a client, advice and guidance to say, well, you can do, you can look into any of these if they apply, so that they're not just pigeonholed into what you happen to do or what you happen to want them to do, or what might be most lucrative for the attorney, because these are all options. People, when they're facing foreclosure, sometimes they're looking to save their house at all costs. Sometimes they're looking to just make the best financial decision they can make. Sometimes they're looking to sell right away. They're just, coming in, they're saying, I know I can't afford this house anymore. It's got a lot of equity. What I'm trying to do is I'm trying to sell it and move to North Carolina where I can buy way more land, or, and any situation like that. So just very kind of briefly, the different options typically are, number one, say someone's behind on the mortgage. They come and they say, well, I've got a bunch of money in savings. I just don't know what my options are, but, if I want to, I can cure it and I can stay at the home. That's always an option, is to cure it, stay in the home. You just got to follow the procedure I was talking there. You're getting the correct amount so that it's all, it all works out, and the bank doesn't come back and say you're $2,000 short, I'm still going to foreclose. Number two, we'll talk about in a minute, is a loan modification. I'm sure you guys have either dealt with those or had clients that have been involved in those a lot. Number three is a reorganization bankruptcy. That's under Chapter 13 or Chapter 11. I'll go through that in a minute as well. Number four is liquidation bankruptcy, which is Chapter 7. And Chapter 7 bankruptcy is not really a good fit to stop a foreclosure long term, but it does stop a foreclosure temporarily. Sometimes that can work when you're trying to sell a house or try to sell a house. Number five is litigation. So you're suing the company, the bank, or the lender that is trying to foreclose. Even in a trustee sale process, you can file a lawsuit to try to stop them. I'll talk about that in a minute as well. The sixth option is a traditional equity sale. That's obviously when the borrower will realize proceeds. So they'll make money off the sale. If they sell it, the house is worth more than the liens against it plus the cost of sale. And then number seven is a short sale, where you're selling it by mutual acceptance from all the lenders, all the lien holders, and you're selling it for less than it's worth and just walking away and not having to owe anyone anything. I'm going to try to go through this fairly quickly just so I can answer any questions you guys have. But for loan modifications are a big thing here in California. There's a huge industry based around these. There was a time back about 10 years ago when a lot of loan modifications were being given by the banks under various congressional, federal laws, because the banks were paid a lot of money under settlements, given a lot of money to basically give these loan modifications, to restructure their loans, oftentimes forgive some of the principal, and a lot of people were saving their homes after they'd fallen way behind on them. One of the reasons for the loan modification splurge from the banks was that a lot of the properties were way underwater. They were worth a lot less than the money that was owed. So from the bank's perspective, it often made sense to keep these people paying on these underperforming assets, because if they had foreclosed, they would not only lose the value of their house. Let's say the house is worth $400,000 and they were owed $700,000. They'd also have to pay for the process. They'd also oftentimes not be able to find anyone to resell it to. So they would do an REO, and then they would not be able to sell it, and they'd have to hold on to it and absorb that cost as well. So it's extremely costly for the banks to deal with the underperforming assets. They oftentimes would just, give these modifications. And unfortunately, a lot of people are kind of stuck in that mindset where they either got a modification before, or they know someone who got a modification, and they think the banks will do this all the time and they fall behind. Maybe they've gotten several modifications and they just continue to think that. And At this time, it's much more difficult to get a loan modification. That was a little bit different during the height of the pandemic, in the sense that a lot of the banks were giving modifications and forbearances in late 2020, early to mid 2021. At this point, from what I've seen, it's back to kind of the status quo that happened before COVID, where it's possible to get loan modifications in some situations, but it's not likely. And for people that are counting on it, it's something you got to be aware, will not always be offered by the bank. The reason this is important, I think, from the real estate side is a lot of people will come, at least to me, and they'll say, well, I'm applying for loan modification. The bank tells me I'm going to get it, or the bank tells me I'm a very good candidate. If I don't get it, then I'll sell. And from the real estate perspective, it's often worth it to say, okay, well, I'll be here as backup. Maybe we can sign a listing agreement as backup, whatever it may be, to know the ins and outs of the loan modification so you can stay there. And if the loan modification is denied, you can be ready to sell. Oftentimes, we won't have a whole lot of time at that point, so you've got to have kind of a plan in place. Oftentimes, what I will do is I'll have them kind of have a plan with a realtor as a backup. So they'll be, let's say I'm helping them with the loan modification. I'll say, if this is denied, you should still have a backup plan. You should still have potential buyers ready. You should have the house all set up, so that if the loan modification is denied and you only got 25 days before the sale, you can actually get the sale done and you won't get foreclosed on or have to incur additional expenses with a bankruptcy or anything else. So really good to have a backup plan, to offer yourself as a backup plan, because sometimes people will say, well, don't bother with loan modification. You'll never get it. Just sell with me. And a lot of borrowers, especially if they really want to keep the house, that's just not very persuasive. They would rather try to keep the house, and if you're going to force their hand by saying, sell because there's no way the bank will give it to you, that doesn't really sound right to them, and they're just going to probably go with somebody else or just continue to go with the loan modification and forget about the sale process. So it's often really good to work hand in hand with that. Just allow them the chance to keep the house and yet have the backup plan to sell the house if they don't get it, because oftentimes they won't get it. One of the main things to know and to think about, along with that prior kind of formula I was talking about, or situation I was talking about, is that as a typical guideline, and this changes with different banks, the borrower's mortgage payment should be between 31 and 50% of their gross household income to be a good candidate for a loan modification. Again, this is just a guideline. It's not set in stone. It's not in every case. But the reason, again, this matters is that a lot of people will come to me and they'll say, I think I'm going to get a loan modification with the bank, so I don't want to sell. And I'll say, well, what is your income right now? And they'll say, well, I don't have a job, and my wife doesn't have a job, and no one in my household has a job. Right now, I'm maybe on unemployment and I get $1,000 a month, or I'm getting Social Security for $1,500 a month, and my mortgage payment is $4,000 a month. And I'll explain to them, there's really almost no way you're going to get a loan modification, because what can the bank modify your loan to? What payment could they give you that would work for them and work for you, that would pay down this $800,000 loan and would, allow you to stay in the house and pay that down? And they say, well, they'll drop it to $500 a month. And I'll, explain that a bank's not going to drop an $800,000 loan, to $500 a month. That often doesn't even, cover the impound, doesn't cover the taxes and insurance. And so if you've got a client who's kind of hanging on and trying a loan modification, but they don't really have any income, then you could be pretty confident that they're going to end up needing to sell. So you can let them go through the process, but again, it's good to have a backup. Same thing with someone who makes a ton of money. Some people come in and they say, I'm making $30,000 a month, and my mortgage payment is $3,500 a month, and I'm trying to get a loan modification. And the bank, if they're looking at it, they say, well, this guy or these people chose to default on this. They have the means to make these payments. They're just choosing to default. That's not every situation, but it's a lot of them. And again, you get someone who's got way more income than the mortgage. So that's like a 10% ratio instead of 31 to 50. Generically, the banks often going to deny it. They're just going to say excess income. There's a lot of other reasons that loan modification is denied. They can deny, banks generally deny loan modifications for any reason they choose. So, within basic reasons. So a bank could say, we deny the loan modification because you've already had 3 loan modifications and that's our limit. They can say, we're denying a loan modification because you're over the conforming loan limit. Your loan was was too high and we don't do jumbo loans at this time. They can deny a loan modification because they say you had a loan modification in the last 2 years. They can even deny a loan modification because they say the investor doesn't do loan modifications right now. A lot of people will come to me and they'll say, well, I want to sue the bank. They didn't give me a loan modification. And I'll explain that it's really at the discretion of the lender. And it's important, again, when you're going through this process, because a lot of people have that misconception. They've either been told by the attorneys, by the internet, we can sue these guys, we can force a loan modification. And that's just really not the way it works under California law. Similarly, a lot of people will be planning to file Chapter 13 bankruptcy to stop a sale if a loan modification doesn't work, if they're behind, if they want to save the house. And in almost all situations, Chapter 13 bankruptcy is a helpful tool if it works, if it will work for the client to save a house. But there's a lot of information here that's important, I think, because a lot of people, similar to loan modification, if you don't have the income to make a bankruptcy case work, a reorganization bankruptcy case work, then this is just going to be a stall tactic and it's not going to save the house. And if they're, got a lot of equity, it's very much worth it to have a backup plan to be able to sell, to be able to do something, because otherwise you're going to lose your equity and get foreclosed on. And I see a lot of people filing Chapter 13 that cannot afford the Chapter 13 case and don't have a backup plan, and they end up losing hundreds of thousands of dollars of equity because they just will not sell because they don't understand how this process works. And so it's very helpful to know that information. So if you file a bankruptcy case, either Chapter 13, Chapter 11, or Chapter 7, it will, in almost all situations, stop the foreclosure. So a day before, the morning of usually, as long as it's done early enough. Anytime if you file this bankruptcy case and if you do certain other things, like you have to take a counseling course beforehand online and get a certificate, there's some other rules, but generally speaking, if you file the case, it will stop the foreclosure sale and the bank will back up the sale by 2 to 4 weeks, sometimes by 2 months, for the bankruptcy case to proceed. And then you go ahead, you file the documents in the bankruptcy case, you file what are called schedules. In the Chapter 13 case, you file what's called a plan. And you say, this is very generic, but generically you would say, well, here's how I'm going to reinstate my mortgage. So typically, let's say someone comes in, they were unemployed for a while, now they're fully employed, their household is making $10,000 a month, they're behind, $60,000 on their mortgage, they don't have many other debts, and their mortgage payment is $3,000 a month. That is a great situation for Chapter 13. They would be able to come in, they would say, okay, well, I'm going to pay back the arrears for $60,000 over a 5-year plan. Maybe the payment will be $1,200 a month, $1,300 a month, plus I'm going to start paying my mortgage payment again. That's about $4,300 a month. If their budget works and they can afford their other income and they got equity, that's a great way for them to keep their house and continue to build equity, and that makes sense. If you get a situation where someone says, I'm unemployed, I'm on Social Security, my mortgage payment is $3,000 a month, I'm behind $60,000, but that's all the income I have, but I have a lot of equity, then Chapter 13 will not really allow them to keep their house unless something dramatic changes with their income, because they go into it and you gotta pay your mortgage and you gotta reinstate or resolve that delinquency, and they just don't have the income to do it. That happens a lot. And when you have a situation like that, you can still file a Chapter 13, but what you want to do is you want to file a Chapter 13 and say, my plan is to sell the house. So oftentimes Chapter 13 and selling can work together in a very, very effective way. So if you go in and you say, I don't have the income, but I have equity and I don't want this house to foreclose, let's say that you've been working, the client's been working with a realtor and is trying to sell it, but they haven't found a buyer yet, or there's some contingency they need to work out, or there's some other issue. And so there's likely to be a sale in the next couple of months, but it can't get done before that foreclosure date. You can file a Chapter 13 case and you can go and stop the foreclosure and go ahead and sell the house through the plan. I deal with that a lot. I deal with a lot of realtors, a lot of clients who are about to sell. They just don't have time because of the foreclosure. The bank will not postpone the sale date and they still want to sell, but they need a couple months. Chapter 13 is a great way to do that. And I just want to give a couple quick caveats. If this person has been filing repeat bankruptcy cases, sometimes the filing will not stop the sale. So it's important to know. Some people, will try loan modifications, will try suing, will try all these things to stop the sale for years. And if you've just missed at least one case in the prior year, or potentially 2 cases in the prior year, The automatic stay has some rules where it may not come into effect, and filing again might not stop the sale. So it's important to know the bankruptcy filing history. Also, with Chapter 13, there's certain debt limits. So if the loan is too big, or if they have other debts that create too high of a total debt amount, they may not qualify. They might need to do a Chapter 11 bankruptcy case, which is more complex and expensive, but still possible. So again, Chapter 11, it's very unusual compared to Chapter 13 in the state, simply because, again, it's extremely expensive, but it's also very much more powerful. So if someone's got a bunch of properties, they've got a rental property that's underwater, if they've got a business situation where they've got a lot of debt and they've just got this property as part of it, if the property is part of a business, that's more of a purview for Chapter 11. I don't want to go into too much detail here because it gets very complicated, but if anyone has questions about Chapter 11 or a situation with that, it's something that I deal with frequently, and I'd be happy to talk to you about that. Just contact me after the seminar or at any point in the future. Chapter 7 bankruptcy is what most people think of when they think of bankruptcy. That's liquidation. That will also stop the foreclosure. Again, the rules apply if people have filed repeated cases or if they don't qualify for Chapter 7. In this case, it would be because they had a prior case too recently, then they can't file Chapter 7. But if you file Chapter 7, it'll stop the sale, but it puts you into a very difficult situation as a realtor trying to sell a house, because the trustee that is assigned to the case can come in, and if they think there's value there that they can sell and actually net proceeds for the estate, they'll step in and they will just take over and hire their own realtor. So a lot of people will be, about to sell, and then the bank will stop the foreclosure, go file Chapter 7. All of a sudden, the trustee can come in, reject the listing agreement, and start, the sale process themselves. And they usually want to do that because they make more money that way. So you don't want to deal with Chapter 7 if you can help it, because you've got that kind of very much a limbo situation where you may not have control over the estate, and you may have to deal with the trustee. Sometimes the trustee will say there's not enough equity here for me to deal with it, or there's exemptions covering this, and they'll abandon the property, and then you might be able to still sell it as a realtor. You might still be able to get your exemption, but there's a lot, or the commission, but there's a lot of oversight on that, and it becomes much more complicated. You really need to be dealing with an attorney that knows bankruptcy on the side to deal with a situation where someone's filed a bankruptcy case, because you can't just proceed business as usual, and you might even run into pitfalls and potential sanctions and so forth if you're doing things that might violate the automatic stay or trying to pursue a debt that the client might owe you without going through the normal bankruptcy process. It can get very, very complicated. Litigation is something that a lot of people try to do or try to ask to do when they're in foreclosure. A lot of times people will say, well, I heard that the bank can't foreclose on me because of X, Y, and Z. I heard, I tried a loan modification and they denied me. That must be illegal. Things like that. There's a lot of firms out there, a lot of companies that frankly are either scams or just very, very close to scams, just very unethical. They'll offer foreclosure defense services, and the typical ones will say, let's do a forensic audit. And so someone will come to them and they'll say, this is my house, I'm thinking of, I don't really have the money to stay in this house. I'm not making enough income. I'm about to sell it, but I heard, or I saw, or I think that the bank did something illegal, and I just want to see if they did something illegal. And I got your flyer that says, you're going to be able to stay at my house, and you have a 100% track record and whatever else. And so these firms will often say, okay, let's do a forensic audit. Let's see if there's any justification for staying in the house. And what I've seen, and I'll just speak from my personal experience, is that these firms will just look at the note and the deed of trust and some of these default documents, and they have these boilerplate programs, and they'll just say, oh, we found a bunch of extremely serious errors, and if you hire us, we'll, pay us a bunch of money, we'll definitely be able to stop this. We'll go in and sue them. We'll seek a restraining order. They will not be able to foreclose because, they violated all these laws, and it was predatory lending, and there was TILA violations and RESPA violations and so forth. And without getting into the weeds here, almost all of that is not legally correct. We'll say it that way. The statute of limitations issues where you can't come after banks for a lot of those things that happened many, many years ago. And most of it is just kind of cobbled together to make it seem like the person has a good case, but usually they don't have what's called standing to bring cases on those kind of things. Now, there's always exceptions. There's always situations in which a bank does do predatory lending, or where there's some kind of private lender that violates laws, or that they don't, for example, explain the default in a notice of default. That's something where you know, you really do have rights and you can go in and sue. But be aware when you get someone talking about forensic audits and litigations, or saying that they are able to force a loan modification, most of the time that's not an effective solution. And most of the time, or at least a lot of the time, that's from a company that's not really telling them the facts and the truth, and they can give better advice from a different attorney, or you know, just kind of figure out and see, take a step back and look at what these people are saying, and just think about it sometimes. In order to stop a trustee sale in a litigation, you have to go in and get what's called a temporary restraining order or a preliminary injunction, and you really got to show a judge that the bank did something that's going to result in irreparable harm, and that there's a probability of success on the merits if they proceed. It's a very high bar. It's not that easy to get a temporary restraining order. It oftentimes depends on the judge, and it's extremely, like, there's so many of these situations with foreclosure where someone just comes in and sues at the last second. The judges are used to them, and it's very hard to get that what's called a TRO, temporary restraining order. So if someone says, well, I'm going to stop the sale with a TRO, or I'm suing and then we'll be able to sell the house, it's important to kind of have a backup plan. Like if that fails and they're ready to file for Chapter 13 bankruptcy to sell the house, that's fine. If that fails and they're willing to just let the house go and lose the sale, that's fine. Although, you know, you kind of want to be there and explain to them we might want to have a plan B so we can finish this and finish the sale we're working on. But again, just like loan modifications, people are too optimistic about these litigation and the situations of these TROs, and you don't want to let that happen without a backup plan if you can help it, because every sale you lose is income you're losing. And if you put a lot of time and effort into these sales, you don't want to let someone just get yanked away at the end by some kind of false promise, you know, where they think that they're going to have more time and the banks can give more time. Sometimes they do, sometimes they don't. You just want to control as much as you can control. That's my opinion, and that's what, you know, from my experience, what you want to do to really maximize your income from the real estate side. There's, you know, the other situation, if you get through that, you know, have an opportunity to sell. You've got equity sales, and you've got short sales. I don't know how much I need to talk to you guys about this with. This is, you know, really what you do for a living, so I'm sure you know all of this. One of the things I've seen from the real estate side, just this is my 2 cents, is that when you've got a situation with foreclosure, the timing's more important. You can do everything right, but if you're up against, you know, 10, 15, 20 days, as you guys know, things always pop up last second. And one of the things that tends to pop up that really ruins a lot of sale opportunities is when there's judgment liens, HOA liens, liens from the past that the borrower says, I have no idea what that is. Maybe it's from a past business. They don't tell you about it. And a lot of realtors will wait until, you know, very late in the process to run these title reports and to see what's out there. My only 2 cents, and this is just kind of a personal preference, is to run those title reports as soon as possible in these processes where there might be any time-sensitive situation, so that if there is a judgment lien on there, if there is some kind of old lien, that you know about it, and so you don't get to the very end and have the borrower say, well, you know, I was going to sell this, but now that I have to pay $120,000 to all these old liens, it's really not worth it for me. I'm going to go a different direction, and you did all that work, and then they walk away. Again, this is something I deal with all the time. You can often negotiate, especially, you know, through a law office, through, you know, some kind of third-party representative. You can often negotiate with the lien holders, and they'll often settle, and they'll let you, you know, settle that debt and sign off on it. This goes for either an equity or a short sale, but you need as much time as possible, because they're not usually going to do that overnight. And if you find out about it 3 days before the sale, it becomes really, really difficult to close that sale. And then, you know, even if that happens, it's good to know about those above options, about bankruptcy, about loan modification, about different things to preserve the sale and to buy more time. But optimally, you would find out about it early, you solve it, and you never have to go down those other roads. A short sale, as I'm sure you guys know, is any sale where the net proceeds from selling the property will fall short of the debt secured by the liens against the property. And that also includes the cost of sale. So keeping in mind, if the house is worth $500,000 and they owe $490,000, it's probably still a short sale because they got to pay your commission, they got to pay closing costs, and they're not going to make any money. So it's a short sale for not walking away with any money. Any short sale requires the consent of all the parties that are not being paid their full demand. So it's pretty obvious and simple with a first mortgage, a second mortgage. But again, a judgment lien, someone else, an attorney lien, something that happened from a divorce. If there's other encumbrances on that property, they need to be dealt with and paid, or they need to be forgiven or settled so that the bank will put in demand and waive the difference. And again, really important to get the title report early, find out any surprises. I can't even tell you how many homeowners have said the only debt they had was their mortgage, and then they have 5 different liens on there that they claim they had no idea they knew about that they existed. Tax liens can be a big issue too. So find out what's on there and then start negotiating and get everyone to sign off. The more time you have, the better. It could be a very effective tool for avoiding foreclosure. It can help borrowers' credit, which is a big deal, I think, compared to bankruptcy, compared to foreclosure. It's a good selling point, and it allows them control oftentimes to walk away in a certain way. So if you get a short sale, you're working with all the parties, it's cooperative, you're not at the mercy of the bank just trying to foreclose on a certain day. It just gives you a lot more power. And a lot of clients, they want to think that they're doing it the right way. And in a lot of ways, doing a short sale is obviously preferable to a foreclosure because you're doing it voluntarily, you're getting away clean, no one's going to come after you, and it's just a very clean way to exit the house, and it's something that you guys can help with very easily. Lenders often prefer the short sales to the foreclosures as well, because again, it allows them to get out of those sticky situations where they have to, get an REO or they have to deal with a house that might be underperforming. It also avoids the time and expense of foreclosure, so it's beneficial to all sides if it's done correctly. Again, get the title report, find out all the liens, everything that's on there for a short sale. The main issues I've seen with short sales have been these last-minute surprises. Another thing with short sales that I think is helpful is with the short sale, let's say you've got a house that's worth, the borrower thinks it's worth $500,000. The loan is, $650,000. And the bank says, well, we came back with an appraisal. It says it's $475,000. Again, you guys may know this, but the more time you have, the better, because if one technique I've used and I've seen be successful is if the bank says it's worth $450,000 and you think it's worth $500,000 and the bank's denying it because they say it's just too low, I'm not going to do a short sale, I'm not going to get it back for this offer that you received at $450,000. You want to come back and be able to get sorry, I might have flipped the numbers there, but basically you want to be able to prove that the offer you're coming to the bank with is worth the value of the house. Because if the bank thinks it's worth, I did flip it. So if the bank thinks it's worth $500,000, you think it's worth $450,000, and they say, well, you got to come to me with a $500,000 offer, and you've been marketing and you've been trying everything you can, and you can't get to $500,000, then you might want to get an appraisal showing what the value is. And if the value is $450,000 or the value comes back at $420,000, they'll often reevaluate that application and they'll often complete a short sale that way. So again, my advice is the more time the better, because you need time to resolve things like that. But it's not a dead end. Sometimes people will say it's a dead end because the application is denied because they say the value is not high enough for the offer you're coming in with. Another route to dealing with that is just to get an appraisal, just to talk to them, just to prove to them that that's the best value they're going to get. And at the end of the day, it's all about just meeting the bank's bottom line. The bank's trying to figure out, is it more profitable for me to do a short sale here or to foreclose? And your job is to make sure that they know it's more profitable to do a short sale. And if you can look at it from that perspective, it's often helpful. There's a series of laws that were enacted in 2013 that provide a lot of guidance and help for short sales or foreclosures. Let me go through this very quickly. It's called the Homeowners Bill of Rights. It's shortened to HBOR often. And a lot of clients, again, or homeowners, they know about this, but they often misinterpret it. It's really, really helpful to read this. Read this if you possibly can, because there's a lot of very specific rules, and the rules are important both for borrowers, but also for banks, and also it's misinterpreted often. And so, for example, the Homeowner Bill of Rights only applies to owner-occupied properties. And a lot of people will file lawsuits under the Homeowners Bill of Rights for a rental property. And banks have been coming back and suing them. They'll accrue $50,000 in attorney fees and sue the client for filing a lawsuit where it was improper because it wasn't even their own home. So it gives and it takes away in some ways, and that's why it's important to really know this. I would go back and just read it, just Google Homeowners Bill of Rights and read as much about it as you can. It's very helpful from every perspective, I think. The Bill of Rights does guarantee a single point of contact. So when you're calling for a short sale, you've got these rights now, and they've got to provide these. So you get a single point of contact. They can't dual track. And this is really important, but often misunderstood. If you're trying to get a short sale, trying to do a short sale application, and the bank is in foreclosure, they have to stop the foreclosure, and they can't foreclose while that application is pending. Extremely important to understand that short sale has to be approved in writing, and the proof of funds or financing has been provided. So you can't just throw a short sale application at them 5 days before a foreclosure and say you have to stop the foreclosure or else you're dual tracking. Many people think that's the rule. It's not. So you have to get that offer in. You've got to get the process going. If there's actually going to be a short sale, then it makes sense. They can't go forward and foreclose once that's been agreed to. But you've got to get that approval. Otherwise, you still really want to look at those other options: loan modification, Chapter 13, Chapter 7, whatever else to make sure you have the time to finish the sale. The completed application, as you see on the bottom there, there's an amendment which says the bank cannot record a notice of default, a notice of sale, or conduct the foreclosure sale. They can't foreclose if the application is complete. Again, make 100% sure they're aware that they're saying that they're confirming it's complete before you do that, because just sending the application in, oftentimes there'll be something missing or it won't be complete for the bank's, from the bank's perspective. And there's just too much value in the work that you guys put in to set up the sale to allow these things to chance. You really need to confirm that the HVOR applies before relying on it, if you're going to rely on it. If the application is in, again, you can't dual track, so it'll stop the foreclosure technically. However, what I've seen in the past, and it's really important to know, is that you can have a short sale application in, and they can be reviewing it, and the foreclosure date can be 14 days away. They can deny the application. They can say, well, this number is not high enough. It's $500,000, but we think the property is worth $550,000, and so we're denying it. It's insufficient value, whatever other reason they deny it for. And they can deny it 2 days before the foreclosure sale, and then they're going forward with the foreclosure. And that's really, really important to know, is that you can't just go in there and feel safe. You really got to track the foreclosure. You can do that online. You can do that directly with the third-party trustee, so forth. You need to have that. Well, you don't need to, but it's wise to have that backup plan. So, for example, if you're doing a short sale, maybe you can say, well, we're going to put this application in, but be ready. Talk to an attorney, or here's a situation. Here's a contact, or whatever it might be. Have a backup plan. Be ready to file that Chapter 7 bankruptcy if you need to. Be ready to file whatever else you need to do if this is denied, so you have a backup plan. Don't just rely on the fact that that application is in, so they're going to back up the sale. If they haven't actually done it yet, you've got to always make sure that on your end, all those boxes are checked and you've got that plan B. Again, lenders are really in control of this process, so you don't want to get in a situation where you're complaining and you're saying, well, I sent in a full application, and they're saying, no, you didn't, because you're not the one with the power to make the decision of whether or not the foreclosure happened. They are. This is an important one. I'm going to go through this briefly. I advise you, or certainly think that it's a good thing to look it up. There's almost all of the pandemic relief programs that have been there to save houses, to stop foreclosures, to do forbearances, to do moratoriums. Almost all of those are now expired. As far as the state is concerned, generally speaking, the pandemic really isn't something that will allow the stalling of this process anymore. So different people have different opinions on it, but it is what it is. There's one program left that is there that will really help people to save their homes, and that a lot of people are finding out about and trying to use. And again, it's just important to know, it's called the California Mortgage Relief Program. I would definitely suggest you look this up. The website's right there. And if you qualify for this program, the bank, and you owe less than $80,000 in arrears on the house, the state will also provide the funds without requiring any payback to pay up to $80,000 to reinstate, and then up to $20,000 of property tax payments that are past due. And there's a lot of rules to apply to qualify. You've got to have a generally low household income. It depends. It relates to the income in your area for household. Property's got to be owner occupied. You've got to have a qualified financial hardship, and that's again kind of up to the bank. The past due amount's got to be less than $80,000 at the time of the application submission. The original unpaid principal balance has got to be lower than the conforming loan limit. Sorry about that. At the time. And again, look on the website. There's a lot of criteria, but I have seen and helped people, numerous people with this. And typically, the state really is reinstating a lot of these mortgages and providing this relief and allowing people to stay in their home. So if people are saying, you know, I applied for this, if this doesn't go through, then I'll sell. It's just good to know, you know, what the rules are, what the criteria are, to give an idea of how much, you know, time and effort to put into this, what to expect, whether they're likely to get it, whether they're not likely to get it. So if someone comes to you and they're making $300,000 a year and that's on their taxes, and they say, well, I applied for this and I'm, you know, $140,000 behind, but I got a lot of equity, you can be pretty confident that they're not going to qualify. And typically these programs are turned around pretty quick as far as the decision. So just knowledge is power in that situation, knowing, you know, how these work and knowing when to really be there as a backup and knowing what to expect, and just communication with the client will, you know, get a lot more sales closed, a lot more, you know, a lot more commissions and so forth. So it's good to know the information on this. Also, the lender must be participating in the program. Most of them are, but good to look up. I mean, you guys will know the lenders dealing with the client, so good to look it up and to know if they participate or not. You might even be able to advise the client, just look at that list, and your bank's not on there, so you might want to have a backup plan in place. There, I listed here some of the past changes and you know, relief. There were some moratoriums that were in effect. There were some forbearances. A lot of banks were voluntarily doing forbearances because of COVID. Less so now. There's really very little protection for clients, so they're kind of coming out of this. And a lot of the clients, what happened, and this is good for real estate sales, honestly, is that they were taking advantage of these moratoriums and they were getting 12, 18, 24-month forbearances because of COVID or you know, during the pandemic, and they fell way behind on the mortgage. And a lot of these, almost all of the forbearances, what they said in the letters they would send out is they said, you know, this is not forgiving. You're not guaranteed a loan modification at the end of this. You can apply for a modification to try to restructure the loan and try to bring these arrears back into the loan, but there's no guarantee, and the bank retains the right to move forward with foreclosure or any remedies at the time, you know, once this forbearance expires. For whatever reason, I'd say 80% of people that got these forbearances just assumed or thought that they were definitely going to be able to just move on and start making their mortgage payments again once the forbearance was over, and they wouldn't have to deal with those arrears and that they'd be put back into the loan. Some of the banks are doing that, but I would say most of them are not, and they require you to apply for a loan modification, or they're just going to move forward with foreclosure. So what happened was kind of a perfect storm where a lot of people fell way behind, either thinking they'd be able to reinstate it or misunderstanding how it works, or just assuming that the bank will work them at the end, and they fell behind. And so now they're facing foreclosure, or they're going to be facing foreclosure, and they're not going to have an easy way to reinstate it if the bank will not give them, you know, a loan modification or some kind of reinstatement ability to fix delinquency. So they both fell behind. At the same time, a lot of them gained a ton of equity in the homes because of the real estate market. And so they find themselves in a situation where they're facing a foreclosure, but they have a lot of equity. And that's kind of a perfect storm for a realtor coming in. A lot of them are going to come to the realization or already just come into it, and they say, look, this is a great opportunity right now, especially with the market starting to turn, to sell a house, to make a bunch of equity. I'm not going to be able to save the house. I'm behind. The bank's not working with me, or maybe even the bank might work with me, but it still seems worth it right now to sell it now that I can make a lot of money off this property. You're going to find a lot of clients, I think, coming into the next few months, into the next year, that are thinking that way, and it's going to present a lot of opportunities, I think, to sell, to really help these people make a lot of money while they can, and to avoid foreclosure, and just to move forward and to reinvest in the future, which is a real good outcome for a lot of the clients. Again, this is, you know, a lot of these last two slides are basically obsolete because this is what happened in the past. Just kind of giving some background and context on what the banks were doing. But at this point, you know, these two slides are pretty much obsolete. Some banks will still be doing some forbearances, but that's completely in their discretion, and you just got to be very vigilant about looking at the options, looking at what the bank's actually doing, and having all these other options at their disposal. Because at the end of the day, from the realtor side, what you're trying to do is make sure that that sale or that short sale is successful. And to do that, you need all the tools at your disposal that you can have to make sure that you have the time to complete that sale or short sale. That's the most important thing, obviously, for the client, for the realtor, for everybody, just to maximize this, because the worst thing a lot of these people can experience is to have a lot of equity in their house, to have an opportunity to make money. Maybe it's the only asset they have, maybe it's the only money they have for their family. And because they don't know the rules, because they don't know the laws, because they misunderstand some of the options, they end up getting foreclosed on. And as I'm sure you guys have seen, you can lose all your equity in a foreclosure. You could lose hundreds of thousands of dollars of equity because the bank will just foreclose and could REO it, or the buyer, there may not be any buyers out there that will pay that amount in the moment, or there may be just people trying to take advantage and lowballing offers. So you can lose a lot of money in foreclosures, and oftentimes the only thing that can save these people and can really get them the money that they've earned is to sell the house and to get as much equity out of the house as possible. And these techniques here that I'm talking about, even if someone is facing a foreclosure in 2 weeks, sometimes it's better to file a Chapter 13, even if you have a current offer, if you're pretty sure that that's a lowball offer or it's going to be a fire sale. And if you had another 2 months, you could get another $100,000. It's easily worth it for them to file that bankruptcy case. And again, if you have specific questions on this, just contact me afterwards. And my contact information here will be at the end. Or contact any attorney that specializes in bankruptcy. But what you want to do is you really want to know those bankruptcy options, because sometimes you can allocate, you can strategically dismiss it in a good faith way to save money, and sometimes you can save it and you can refile it. You can file and sell the house through the plan. It just really depends on the client's bottom line, but there's a lot of different options in bankruptcy that will allow you to sell, buy time. Sometimes 3, 4, 5, 6 months. And Chapter 11, you can sometimes buy over a year to sell it. And so if someone's about to sell, but they can make a lot more money if they had 2, 3, 4 months, it's often very important, I think, from their perspective, to look at this and say, well, I can make more money. The realtor could make more money. It benefits everybody. Let's at least have these options on the table so they can make an informed decision about what they're trying to do. Again, here is my contact information. You can always email me or call my office. The best way to contact me is by email. My email address is amoher@morelaw.com. I'm happy to answer any questions. I didn't see anything on the chat, but to be honest, we're trying to figure this out at the last second as far as the chat, and I'm not sure if it's working or if the chats are going through. So if you guys sent anything to me and I didn't get it, just feel free to contact me. I'm happy to answer any questions. Hopefully this was a little bit helpful for you guys, and I appreciate your time, and thank you for being here.